I'm Verna Williams, and I am the Dean of the College of Law here at the University of Cincinnati, and welcome to the Schott Lecture. Annually, the College of Law recognizes the distinguished scholarly contributions of individual members of the faculty through the Harold C. Schott Scholarship Award. This award honors outstanding research and scholarly achievement by a Cincinnati Law faculty member based on a collective body of work. The recipient for the 2021 academic year is Professor Felix Chang, Professor of Law, Co-Director of the Corporate Law Center, and Associate Dean for Faculty and Research. Professor Chang's research spans broad areas of markets, inheritance, and inequality. In antitrust and financial regulation, his prior work examined the balance between competition and systemic risk in the derivatives markets. Currently, he is developing new tools for antitrust research through topic modeling, an algorithm that maps the statistical relationships among words, which can illuminate patterns in how courts interpret doctrines on market power and the antitrust regulation balance. He's also fusing antitrust with approaches from race and law in the setting of ethnically segmented markets, where buyers hail from one ethnic group while sellers hail from another. In the areas of inheritance and inequality, Professor Chang has written on the redistributive potential of legal rules in trusts and estates. Currently, he's working on how inheritance law exacerbates and redresses wealth inequality in China and the United States. In his research, Professor Chang frequently turns to comparative law to highlight how institutions, cultures, and doctrines in different settings can shape law. His most recent book, Roma Rights and Civil Rights, a transatlantic comparison, was published by Cambridge University Press in 2020. This book traces the parallels between the European Union's Roma inclusion initiatives and the US's civil rights movement. Professor Chang received his BA from Yale, his JD from Michigan, and his scholarship brings together many insights from many disciplines to analyze and clarify critical issues pertaining to markets, inheritance, and inequality. With this Schott Award, we recognize his important and influential work. And so without further ado, it's my pleasure to present to you Professor Felix Chang.
Hi, everyone. Thanks so much, Dean Williams, for the really kind introduction. Thanks very much to my colleagues at the College of Law for honoring me with this award. I know that I'm following in the footsteps of scholars like Professors Aaron, Kogan, Godsey, Kalsum, and Sperino, so it's a real honor to be here. Today, I'm going to be talking about two dimensions of inequality, two perspectives on how law contributes to and perhaps redresses inequality. So just a trigger warning for the audience, I'm going to be incorporating parts of critical race theory into my talk. I'm going to be delving into topics like race, racialization, wealth inequality, and wealth redistribution. You can't talk about inequality without talking about these things. But I'll also talk quite a bit about law and economics. Because the Schott honors a collective body of work, I'm going to begin by looking at some of the very first research questions that I sought to answer. And these questions were what had spurred my academic interests in inequality. So I'm going to share a series of prezzies. Here we go. Early on, I became interested in how to properly balance antitrust and regulation, in particular antitrust in financial regulation. The context for some of my very first explorations of that balance was a market for financial derivatives. So I'd come to UC from a background as in-house counsel at Fifth Third Bank during the financial crisis. That was when regulations around derivatives trading were being rewritten. And I thought it was just a really interesting time to dive into academia. So just very quick primer, very quick microeconomic primer. You might have seen this before, but the foundation for our discussion of antitrust is that monopolies adversely affect competition. When markets are distorted by powerful players, harms will flow to competition. If a dominant firm underprices new entrants into the market, harms will also flow to consumers, because with market power comes the ability to charge super competitive or really high prices. So you can see this predicament illustrated in this classic graphic, which you might have encountered before. In pure competition, you've got marginal cost that equals to price. So you got a couple of triangles here. What happens is that if you price at close to marginal cost, it's a fancy way of saying if you price low enough, this green triangle is consumer surplus. So that's everything that consumers gain because you're not pricing as much as you could be. What happens when you move to a monopoly situation is that consumer surplus is diminished at the expense of higher producer surplus, and that engenders deadweight loss, which is the loss to the society. Now, really practically, that means that you've got monopolies and oligopolies that might have incentives to reduce either the quantity of production so as to raise prices or reduce quality. And that's going to come at a loss to consumers. So some examples of where you have the vast majority of the market cornered by either a monopoly or a small group of firms. I'm going to start with the small group of firms. You have airlines. 4 carriers dominate the market for airlines: American, Delta, United, and Southwest. Credit cards, there are 3 major issuers that dominate: Visa, MasterCard, and American Express. Well, it turns out that the derivatives markets exhibited the really same oligopolistic behavior. So derivatives are this instrument that's widely thought to have precipitated the financial crisis. It's basically an instrument whose value is based on the value of other assets or variables. So you've got the movement of interest rates or the price of stock, or whether a party defaults on an underlying obligation like a loan. Derivatives can heighten the risks of the underlying transaction. They can also be a really good way of hedging the risk. For instance, fluctuating interest risk that a borrower undertakes. So this illustration is a classic derivative. It's an interest rate swap. It looks like this. If you've got a borrower who has a variable rate loan, maybe a loan of, that's based on 1-year LIBOR plus 3%, at a time when LIBOR is hovering around 2%, that looks like a 5% loan, but the borrower doesn't like the volatility to of a variable rate loan. So then they might purchase an interest rate swap, in exchange for which the swap seller gets them a fixed rate loan, and then the swap buyer, which is a borrower, is going to basically come out with the equivalent of a synthetic fixed rate loan. All right, so that's the underlying instrument. What does that have to do with market power in the derivatives market? Well, this is an illustration in some of my very first investigations into the derivatives markets of what that market looks like. So this figure shows what's called the notional amount, or the derivatives, the amount of the underlying derivatives transactions for the top 9 bank holding companies in the US. So think of these as the really large financial institutions who are the biggest buyers and sellers of derivatives instruments in the country. These numbers are incidentally taken from the OCC, which is a bank regulator. They compile quarterly reports on derivatives positions. So what you see is this market that's dominated by 5 large firms. You've got Citi, JP Morgan Chase, Goldman Sachs, Bank of America, and Morgan Stanley. It turns out that this is an oligopoly. So from year to year, these top 5 bank holding companies have always dominated the derivatives markets. It's a really concentrated market. These 5 large bank holding companies, they're ranked at roughly 5 to 6 times the next largest player, which is the 6th largest bank holding company. So by many measures of market concentration, you can go with the 4-firm concentration ratio or the Herfindahl-Hirschman index. This market is either really concentrated or moderately concentrated. What's really interesting is that year to year, it's always the same 5 firms that occupy 91 and 95% of the market. So this derivatives trading market has been dominated for decades by these top bank holding companies. Now, this was my early work, and it instilled 2 really powerful lessons in me. The first was that the stability of this oligopoly over time suggests there was something that was amiss. Either these large 5 bank holding companies were utilizing some mechanisms to maintain control over the vast majority of the derivatives trading market and shutting out competitors, or something else strange was amiss. Later, some of my research then delved into how the Dodd-Frank financial reforms strengthened the hand of these large derivatives dealers. Happy to talk about that during Q&A. The second powerful lesson for me was that, the dominant firms can compete intensely amongst each other. So you see really strong intra-group competition, but they can nonetheless find a way to band together to shut out smaller competitors. So those are the two really important lessons from my early work. Let me now segue into the first of the two perspectives on inequality that I'll be talking about, which is interracial inequality. I'm particularly interested in a particular type of interracial inequality as manifested in this really peculiar market. So this is the ethnically segmented market. I'm looking at ethnically segmented markets in this perspective on inequality. So for those of us in antitrust, we know what segmented markets are. They're markets that divide along the distinct preferences of producers or consumers. In ethnically segmented markets, that segmentation happens along, ethnically homogeneous consumers or producers. So some examples might be food products. Food products might be consumed by a particular ethnic group. Other examples of ethnically segmented markets include ethnic beauty products. You can have restrictive covenants as well. That's where in the sordid housing history of the US, you had white homeowners who had banded together to exclude non-white purchasers. What happens is then you segment a city's housing stock and you can inflate home values in white neighborhoods. Other examples of ethnically segmented markets include racially exclusive labor unions. So that's where labor unions might exclude non-white members, African-American and Chinese American members, so thereby it inflates union pay. Now, the concept that I'm particularly interested in this perspective on inequality is the market where consumers are drawn from one ethnic group and producers are drawn from another. So as far as I could tell, these markets didn't necessarily have a name, and so I just made up a name for them. I just called them ethnically segmented and misaligned markets. Now, in the US, one of the clearest examples of this type of market, where it's both ethnically segmented and ethnically misaligned, in that producers are one ethnic group and consumers are another, that's the market for wigs and hair extensions, consumed mainly by African Americans. But in this country, they're sold mainly by Korean American retailers. For reasons that I'll explain later, I'm interested in these ethnically misaligned markets where both producers and consumers are both peoples of color. If you look elsewhere, it might be both where consumers and producers are ethnic minorities. For me personally, that's really interesting because in this market for wigs and hair extensions, where consumers are mainly African Americans, but producers are Korean Americans, you've got natural frictions that happen as a result of market transactions, but they're amplified by interracial differences. And so I've been really interested at not just the inequality perspective, but how these types of markets frustrate interracial solidarities. So the conundrum that we have at the heart of these types of markets is, why do they persist? Why are they continuing to be ethnically misaligned? You would think, after all, that this just doesn't make a whole lot of sense from perspectives from economics, sociology, and for our part, law. It doesn't make a lot of sense why, if producers are drawn from one ethnic group, they can maintain that dominance in selling to consumers from another ethnic group. So let me then quickly walk you through some of the literatures that in this area I had built upon. In the contributions from law, I think legal scholarship can be divided into three distinct categories. There's the antitrust literature and the case law on market definition or market division. There's race and law literature on racial cartels. So that borrows from antitrust to explain why and how whites can exclude peoples of color from housing, labor, political, and other markets. And then there's this whole law and development literature on the interplay between ethnicity and markets. So that borrows from people like Barak Richmond, Lance Howe, Eleanor Brown, Amy Chua, and Eleanor Fox. There's also contributions from sociology that include foundational work on ethnic entrepreneurs. This was really the work of Ivan Light and Edna Bonicic. They had undertaken a series of studies in the 1980s about Korean immigrant entrepreneurs in Los Angeles. This work became really foundational for legal scholars' understanding of ethnic entrepreneurs. By the way, it predated the 1992 Los Angeles uprisings, where, at least in the popular media portrayals, it seemed like African Americans were pitted against Korean Americans. So some of the other work from sociology, they cover the tendency of ethnic entrepreneurs to buy from their own. So in Miami, for instance, Cuban American retailers tended to buy from Cuban American wholesalers and distributors. That tends to keep money within an ethnic community. The other piece that's really important here is the literature on ethnic and racial formation. And here, some of the classic writers are Omi and Winant. So that basically says that racial formation is this dynamic and contested process. It's informed by class, ethnicity, and political struggle. It's important to keep in mind because as we move forward, it challenges our underlying assumptions about ethnic solidarity. Okay, and then finally, there's a good deal of work from economics about race and ethnicity. Here I've listed some of the pertinent literature. We probably can't talk about race and ethnicity in law in economics without mentioning Gary Becker's works, The Economics of Discrimination. So a lot of this hypothesis has been debunked, but one thread that continues today from Becker's work is that notions like segregation, discrimination, and then by extension, market segmentation, they're economically inefficient. They keep price from flowing where it otherwise would, and they artificially inflate prices. There's some interesting and relevant work on ethically segmented societies from political scientists. So Amanda Robinson, for instance, is a political scientist who's written on Malawi, which is this really diverse country in sub-Saharan Africa where ethnic groups tend to transact with their own in-group counterparties. And segmentation, she's found, tends to be fueled by interethnic suspicion. Now, onto the markets that I'm looking at, which is the markets for wigs and hair extensions consumed primarily by African Americans. So this is a market that pretty much every African American woman knows. They also know that it tends to be dominated by Korean Americans. You can imagine that this dominance by outsiders has been a source of frustration and anger because there are really few successful African-American retailers in this space. The frustration has erupted into outbursts and outbreaks like vandalism and looting of ethnic beauty supply stores in Los Angeles in 1992. Interestingly, in Ferguson in 2014, there was lootings of Korean-owned ethnic beauty supply stores after Michael Brown. Also in 2015 in Baltimore after Freddie Gray was killed. This is a market that's made its way into movies with the adaptation of The Sun Is Also a Star and Chris Rock's Good Hair documentary. So this market is said to be around 80 to 85% controlled by Korean American firms. It's an interesting question of how Korean American firms came to dominate this industry. And in short, there's a historical and structural explanation. It starts in the 1950s, in 1960s. Hair collectors would go around the countryside collecting hair from girls and women. And then that hair would go directly into wigs that Korean factories were manufacturing. Consumer demand in the US was steadily growing for hair pieces throughout the 1960s. This was, after all, the era of big hair. At the time, the top shelf imports of hair was thought to be imports from Europe, and that wasn't sufficient to keep up with consumer demand. So then the US distributors started sourcing from East Asia. But then in 1965, the Treasury Department banned the import of wigs from China, and so that instantly boosted wigs imported from South America. Incidentally, 1965 was also the passage of the Immigration and Nationalities Act that had lifted immigration restrictions from Asia. And so a lot of Korean immigrants came to the US. They were oftentimes well-educated, but because of the glass ceiling, they had to start businesses. They couldn't make their way in the traditional employment sectors. So frequently this meant that they would become entrepreneurs in the ethnic beauty supplies sector and also convenience stores in Los Angeles. There are other structural reasons for the success of Korean Americans vis-a-vis their African American competitors. And this includes things like the difficulty for structural reasons of African American firms to get bank financing, making it difficult for them to finance and procure product. Now, this is a market that's rife with mistrust and allegations that sound in antitrust. There have been consistently charges of exclusion and conspiracy leveled against Korean American producers and retailers by African American competitors. It's not just conjecture. So in 1975, the US Department of Justice brought action against the Korean Hair Goods Association in New York. So then they entered into a consent decree that had enjoined the association from fixing the price of wigs, preventing the procurement of wigs for resale, like informational exchanges, in restricting membership, so as to unreasonably restrict the ability to get the ability of retailers to get their hands on product. Now, to fully assess the viability of antitrust claims, especially on exclusion, we have to scrutinize the market power in this market. Here we have to face another quandary then, and this implicates some of the very first lessons that I gleaned from the derivatives markets, which is, market power is often measured at the firm level. Can it really be said that as a whole, as a collective, Korean Americans exert market power over this market? Korean Americans are an ethnic group. How can they exert market power as an ethnic group? Because in this market, the producers and retailers are thousands to tens of thousands of small, discrete firms. Now, this is a theoretical matter, but if we cycle through the different gauges of market power, we find that none of the existing frameworks really answers this question directly. But it does seem to be that Korean American firms can compete intensely against one another as retailers while finding ways to shut out African American insurgents. Product catalogs are solely in the Korean language. African American products that are innovated are not distributed by Korean American retailers. So there's both what looks like classic examples of collusion and exclusion under antitrust that's going on. What's happened in recent years is really interesting because with the advent of the internet and China as a major manufacturer, you get alternative sources and distribution strategies that African American competitors are availing themselves out of. So a lot of hair happens now to be cut in China. It's bundled then into wigs that are manufactured in China. And here you see pictures of factories that I had taken when I was doing field work in China of these hair processing facilities. So this is what that looks like in China. And then this is this huge beauty exchange center in Guangzhou, which is one of the world's largest port cities. So what's happening is that you're now beginning to get African-American owned competitors. These are upstarts like Maven and Indique, and they're beginning to distribute products made out of China that are not distributed traditionally like in brick and mortar stores, but they're distributed through Black-owned hair salons. Okay, finally, let me take you through this second perspective. This is my second perspective on inequality, and that is my perspective on wealth inequality. So here I'm going to share the final set of slides. This is borrowing from a really different area of research. So this is not antitrust or financial regulation, but this is trust in estates, which I've had the pleasure of getting to know from picking up the class Wills and Estates at the University of Cincinnati. So my current work in trust and estates articulates this framework for prioritizing reforms that now trust and estate scholars are beginning to tinker with. So T&E scholars are now really worried about wealth inequality. And as a field, it makes sense why trust and estate scholars should be thinking about this stuff. After all, this is a field where we have the gratuitous transmission of wealth, often across generations. So my work now in this area makes the case that trust and estates should prioritize intergenerational economic mobility above other goals. So intergenerational economic mobility is the ability of one generation to move beyond the previous generation's economic station. In practice, then, what does that mean when you translate this into legal reform? That means you embrace reforms that spur really ultra-wealthy households to begin to lose some of their wealth over time, so that if you think about a wealth curve as a bell curve, over time, at the very high end of the bell curve, they will slouch toward the mean. There will be some sort of mean regression. Practically at the very low end, in really low income households, that might mean that you allow low income households to amass enough wealth to transmit it across generations so that they are allowed to build up wealth over time. Now, to set the stage, I situate my work into reform proposals that trust and estate scholars have undertaken in recent years. This is my own taxonomy of those proposals. So in 1990, Mark Asher, who's a scholar at Texas, he proposes this really harsh escheatment rule, whereby if somebody dies, the decedent's property is going to be sold, and then the proceeds are entirely turned over to the government, with very few exceptions. So the normative underpinning of Asher's harsh escheat rule wasn't really so much about wealth inequality as it was the unfairness of what's called dead hand control. So that's the ability of settlers who set up trusts that might be able to last in perpetuity. That's the control they exert over assets really forever, theoretically in perpetuity. It's also the unfairness of people being born into families that can really dictate their station in life and that have really few intersections with their own merit or their own hard work. So in recent years now, you see more and more scholars that are engaging with not only inequality, but also economic analysis in trust and estates, which had been quite rare, but it's really refreshing. I think that reform in trust and estates has taken so long for a number of reasons. So T&E was always thought to be comprised of rules and doctrine that revolve around a really small number of players. So trust and estates rules and doctrines tend to govern dynamics among family members and estate fiduciaries. So if you analyze these laws from an economic perspective, the potential for redistribution is going to be really limited. It's this really microeconomic perspective. The second reason is trust and estates as a field is really rulesy. So you have a lot of rules, as my students in wills and estates know. You have a whole slew of rules around, wills execution. And in the law and economics tradition, it's always been thought that if you want to redistribute wealth, legal rules are a terrible way to do it. It's called the double distortion argument. It's better that we have really strong tax code, because the tax system is where you really want to redistribute wealth, you don't want to effectuate redistribution through legal rules. But what's happened is that, especially after 2016, we have a slew of reform proposals for the trust and estates rules. I think that's in part because trust and estates scholars really see the pernicious effects of wealth inequality. They see political instability and social instability. So in my categorization, these wealth come in two forms. One is that you've got reforms targeting the ultra wealthy end of that wealth bell curve, where you've got things like high estate taxes, the rule against perpetuities, because trusts oftentimes are an input into generation skipping transfer taxes. And then you've also got asset protection trusts. So these are the types of reforms and the types of instruments that are really salient for reform at the really high end. For reforms targeting lower income households, you've got things like intestacy, because it's really the most prominent. So I think of trust and estates as a perfectly apt place to push back against inequality. So my argument here is that the animating principle for reform of trust and estates is that this field should advance intergenerational economic mobility, or again, the ability of children to move beyond the economic station of their parents. So I think that this taps into normative attitudes that society holds, so that even if we're kind of comfortable with income inequality, because income might translate as a measure of hard work, society might view the ability of children to move up and down that economic ladder as profoundly unfair if it's going to be really limited. So now let me walk you through some of the socioeconomic foundations for this argument. The first pillar of this work is really hails from economists like Miles Korak, who have looked at this correlation between intergenerational economic mobility and inequality. So they find that inequality tends to be sticky across generations. That's a fancy way of saying that inequality really lingers around for many generations. This is what's known as the Great Gatsby curve from Miles Korak and other scholars of intergenerational economic mobility. they find that in societies with really high income inequality, it is very difficult for future generations to earn more or less than what their parents had earned. So this is this correlation between wealth inequality and a very inelastic form of intergenerational economic mobility. Now, to me, I think that intergenerational economic mobility should be the central concern of trust in estates reforms. As a field, trust in estates is concerned with the gratuitous transmission of wealth, oftentimes across generations. And then the transmission of wealth across generations happens to be kind of the interstices at which you can lock in income inequality across generations. So put differently, in any given generation, you might have huge variations in income. So that's going to be income inequality. But you will lock in income inequality intergenerationally, that is across generations, if you then allow really wealthy or high earners to then pass on their wealth gratuitously to their next generation, so that the next generation that descends from high income households tend to also start with this head start of very high wealth transfers. So I think that we might as a society tolerate some form of income inequality. And by the way, income inequality is going to be just kind of the necessary evil of a really imperfect system of business laws, where you've got corporate laws and antitrust laws and financial regulations that might, to some extent, allow some degree of wealth and income inequality at one generation, but that does not mean that that wealth inequality should be locked in for perpetuity for future generations. Okay, let me now then look at these two ends of that wealth distribution bell curve. So for really high ends, that estate taxes are going to be the driving force at how you can combat accelerating wealth inequality over generations. So this slide shows you what's happened over time, in which you've got this diminution of the estate tax rate over time. That's the line that you see. But over time, you also see this increase in the exclusion. So that is, estates below this exclusion will not be taxed. This exclusion has grown really over time. In the 1970s, when this graph begins, it was well under $1 million. It was like $330,000. So that's grown steadily. Under Bush, it grew to $1 million, then 2 million, and then the exclusion then is up to now where it's just under $12 million. So that means that estates south of $12 million will not be taxed. At the same time, what's happened is that the estate tax rate has gone down, so that you're taxed on the margins that you have in a really high value estate above $12 million at this declining rate. Now, as a field, again, trust estates is concerned with the gratuitous transmission of wealth that oftentimes occurs across generations. It might be in perpetuity, where perpetual trusts are concerned. So perpetual trusts are this creature, ironically, of the sorry, I've got this automatic timer that goes off if I don't move. So perpetual trusts are this creature of the 1986 amendments, the generation skipping tax transfer. And what that basically said was that, look, as long as you have assets sequestered in trust, they won't be taxed until the trust is dismantled. So that means that this estate tax will never enter the picture until then. But what happens over time is that the rule against perpetuities, it gets reformed over time. So hopefully for those of you who've taken property, you'll remember probably with dread, think about first year property, that rule against perpetuities, where a contingent interest, if it has to vest, it has to vest within 21 years within the life of being at the time when the interest was created. So that is really difficult to administer. And what states did over time is they began to unwind the rules against perpetuities. Some states have abolished it outright. So that means that, for perpetual trust, they will never get taxed at this declining estate tax rate until the trust terminates. So that's at the very high end. For the sake of time, I think I'm just going to skip now to the remainder of my slides to take you through the next macroeconomic pillar of reforms in trust and estates. So this is now turning from the very high end to the lower end, so low income households. Here, the macroeconomic pillar is the work of scholars who've traced the splintering of family compositions across economic lines over time. A lot of this work comes from Betsy Stevenson and Justin Wolfers at Michigan, but here I'm taking figures from Shelley Lundberg. So this is really interesting. In the past quarter century, we've seen declines in both marriage rates and divorce rates in the US. How can you have declines in both rates? And it turns out that society is becoming bifurcated. For higher income households, you're seeing technological improvements that have made home care easier, delayed childbirth, higher educational attainment among women, which has somewhat begun to close this gendered wage gap. So now as a result, marriage is now binding couples who are more on similar economic footing, and marriage is the option of higher income households. Among lower income households, you're seeing marriage becoming less frequent. It's oftentimes replaced by cohabitation. So it's a bimodal distribution. It reveals that marriage is becoming restricted to couples who are more similar than different. So the ensuing marriages are going to be much more stable. This bimodal distribution has incidentally also come to characterize the instruments of trust and estates. On one hand, you've got trusts like perpetual trusts, asset protection trusts, and non-probate instruments that cater to the privacy desires and the dynastic aspirations of the hyper-wealthy. But on the other hand, you've got intestacy in the probate system, which serve lower income households really terribly. You know, it's public, so it throws intrafamilial conflict into the public view. And then for lower income households, you really have intestacy that stands as really the highest barrier to the intergenerational transmission of wealth. Intestacy tends to favor what's called traditional households, so households that are married. And if they're not married, then interests and properties tend to be splintered over time. So that's why scholars have recommended a number of improvements to intestacy over time. This is just very quickly a graph that shows the increase in cohabitation, especially among households with lower educational attainment. Okay, I'm going to conclude with a very quickly, just a very quick overview of intestacy reforms. So for lower income households, intestacy is thought to stand in the way of the intergenerational transmission of wealth. And for that reason, you have a whole bunch of trust and estate scholars who are now promulgating reforms to make it easier for lower income households to write wills. So one example might be that everybody has to write a will. If you file taxes, you have to have a schedule that's appended to your tax returns. That's a will. Another thing might be, well, to the extent that lower income households might have some non-probate transfers like insurance or retirement plans, probate designations should follow those non-probate designations. The whole thinking is that we want to avoid intestacy because the default rules in intestacy serve lower income households terribly. You've got decedents, if they don't know about or don't spend their assets down, then what happens is assets get splintered over time across multiple generations, making, say, the interest in the house really difficult to pledge or to hypothecate for a loan that you can take out to purchase a business. It makes it really difficult then for those goods to be passed down across generations. I think I'm just one more quick thing and I'm going to stop sharing so that you can all see me, but the takeaway in terms of how trust and estates can foster intergenerational economic mobility is that the starting points is at the extreme ends of the wealth distribution bell curve make it more difficult for higher income households or ultra wealthy households to pass on their wealth in perpetuities. So reform the rule against perpetuities, and make it much more difficult for higher income households to have asset protection trusts, strengthen creditors' rights vis-a-vis beneficiaries and settlors in asset protection trusts. At the very low end, maybe make it so that intestacy does not encompass such a broad swath of society. I think I'm going to conclude there so that we have about 20-25 minutes for questions.
Hey, Felix. From Joyce Lavender, has your research considered the discriminatory practices of SS, veterans benefit, Social Security, veterans benefits and housing access for AA on the intergenerational gratuitous transmission of wealth in the post-New Deal era to present day?
Thanks for your question, Joyce. My research is not veterans benefits and Social Security benefits. It's not a realm that I'm really familiar with. You know, in the trust and estates practice, there are ways of structuring trusts so that you can avail your clients of federal benefits like Medicaid and Medicare. I don't quite know how federal benefits interfaces with that. I suspect there's a story there, as you're intimating. I suppose if one thing to think about is that in the post-New Deal era and during the New Deal era, there's been a lot of research now that, you know, these New Deal reforms are really discriminatory, not only in practice, but also in design, that they weren't thought to encompass broad swaths of society. So today, with these major reforms that President Biden is deliberating and Congress is discussing, you're hearkening back to the New Deal era. But as a scholar of financial regulation, thinking about redlining and banks' discriminatory lending practices, I can tell you that what you're suggesting is absolutely right, that there was a pattern in practice of discrimination along racial lines in federal agencies. So I hope that that roundabout way of touching upon your question helps.
From Mr. Schuler, Richard Schuler, do you include foundations in your research where family members are hired in perpetuity?
Yeah, Richard, it sounds like you and I should talk because it sounds like you're familiar with these types of charitable trusts. I'm assuming that you're referring to these types of charitable trusts where for charitable reasons, you might be able to defer or to not pay taxes at all because they're for charitable purposes. I have looked at those. They're quite complicated and beyond my comprehension as a mere academic, but this is the way that some really high net worth families in the US manage to retain their wealth. So like the Walton family, the inheritors of Walmart and Sam's Club, a lot of their wealth is tied up in charitable trusts where they can really reap the incomes that are spun off the trusts while not paying taxes. So I am aware of these. I feel like I should get a better handle of those. And it sounds like, Richard, you and I should talk after this.
And then Charleston Wong, beyond wigs and hairpiece retailing, it appears to me that general food retailing is itself segmented, e.g. lack of supermarkets in urban poor.
Yeah, I think that's right, Charleston. Thank you for attending, by the way. I know who you are. I follow your blog. And so I think I just want to mention the wigs and hair extension market because I think it's particularly interesting. So oftentimes there will be analogies to other businesses. You might have liquor stores or convenience stores that Black and brown communities oftentimes will complain about. These are, not to generalize, but oftentimes run by immigrants. Just to give you more personal dimension to the story, the reason why I'm really interested in these ethnically segmented markets is, you know, Cincinnati is my hometown. A lot of you know that. And when I was growing up, my parents had a convenience store in Cumminsville. So it's right across, you see the Hopple exit. It's on Beekman Street. And so that is a classic example of these types of ethnic businesses that are in Black and brown communities. It was a predominantly African-American community. And we had bought that store from a Palestinian family. We sold it to a Palestinian family. And so oftentimes you see the ire among Black and brown communities that it's these immigrants who are running these stores. I think there are some analogies to the fact that in the urban poor, you've got food deserts, you've got lack of choices. And so you do have this proliferation of convenience stores and liquor stores that tend to sell at inflated prices. Now, the inflated prices might be able to be explained by antitrust economics. The reason why I think that those are slightly distinguishable is that if you think about market definition, the market for hair pieces tends to be a market where consumers are almost entirely one race. You might argue that it's the same in food deserts, where as a result of geographic market definition, the urban poor, if they're Black and brown communities, don't have much choice. But today there's much more choice. You've got internet retailers, you've got transportation, you can drive to the next narrowly defined geographic market. Now, if you think about wigs and hair extensions, there are in practice real phenomenon like hair discrimination that makes it sometimes really difficult for African Americans to find legal recourse if they're discriminated against by employers for wearing natural hair. What does that mean? That means that this is not only an ethnically segmented market, but a market in which demand is really inelastic. And so in inelastic markets, you tend to see higher market power. I think that these markets are sui generis, they're really unique. And that's why, in my work, I do analogize to convenience stores and liquor stores. That's because some of the early ethnographic work by sociologists had been undertaken in Los Angeles, in Korean greengrocers in New York and Chicago. But I think that the market for wigs and hair extensions is even more distinct than that, because the ethnic misalignment between producers and consumers is even sharper. Thanks for your question.
And Charleston says, thank you. Also, Joyce Lavender, yes, among some practices, the withholding of Social Security benefits for domestic workers and the failure for veterans to qualify for vet admin benefits for housing. Thank you.
Thanks, Joyce.
Wallace Holtzman, if you could please ask your question in the chat box, that'd be great.
Jenny, should I take this question? I'm scrolling through the chat myself from Greg Darley Emerson.
Oh, there's one from Jack Fuchs above it. I'm sorry.
Okay, I see.
Okay. Are there any estate law reforms that you might propose that satisfy the standard of what Thaler calls libertarian paternalism, which would make the reforms more palatable to conservatives who oppose mandates?
Yes. Yeah. That's a really good question, Jack. So Jack's question is basically, look, there's some sort of interest convergence that's going on between, your classic liberals who are really free market, and then let's just say Marxists who are on the left, because both sides agree that there should be a modicum of income inequality that might signal hard work, might signal merit, might signal natural skills that you're born with. But across generations, that is over time, there should not be this perpetuation of wealth inequality that is locked in. I actually think that trust in the states might be where the action is at. It might be where you might be able to get some real good convergences of interests. Today, I think both the right and the left agree that the system is rigged. It's an economic system that's rigged in favor of wealthy elites. And so the Paradise Leaks, the Panama Papers illustrate that it seems like the only people who pay taxes are really suckers who can't afford the coterie of lawyers and financial planners that the ultra wealthy have to pay. And so an example of that is today is we're talking about a wealth tax. Well, the really aggressive wealth tax that had been proposed by, I think it was Elizabeth Warren, is not going to be taxed. So, that's this tax on deferred stock holdings of your billionaire entrepreneurs. That's not going to pass. And so what seems to be lower hanging and more palatable fruit is just maybe a tax on millionaires. So with that premise, let me talk about why I think that trust in the states is a really good way of pushing back. I think at the very high end, if you shore up the rule against perpetuities. So there's been this reform effort that's been going on in the past couple of decades. The rule against perpetuities is thought to be this malpractice trap. Reforms include like this wait and see approach. Hey, let's just wait for 90 years to see if there's an interest, contingent interest that vests over 90 years. Other states say, let's just wait 1,000 years. Other states will say, well, let's just abolish the rule against perpetuities altogether. If we're able to abolish the rule against, if we're able to shore up again the rule against perpetuities so that, these perpetual trusts can last for only as long as the state rule against perpetuities allows them to, and it's a really robust rule against perpetuities, at some point those trusts will terminate and they'll be subject to taxation. We make it very difficult then for settlers to pour over the assets from that terminated trust into another trust. I think that that's something that maybe conservatives and libertarians might be able to sign on to, which is, there's a pushback against taxes from the libertarian end, fine, let's not talk about taxes then, but let's make it more difficult for the hyper-rich to sequester their assets in trust. Incidentally, from the Paradise and Panama Papers, we see that a lot of these trusts are what's called offshore trusts in jurisdictions that are very friendly to debtors in settlers. So maybe in these trusts as well, we should shore up the creditor protections. That is, make it easier for creditors to claw back at monies that are owed to them by settlers who squirrel away their assets in asset protection trusts. So I think that for these reasons, there might be some convergence among the right and the left if we think more about trust and estates as having this body of doctrines and rules that permit the gratuitous transfer of wealth, oftentimes across generations. If we make that more difficult for at the very high end, in a way that doesn't necessarily implicate taxes, that might actually be quite palatable to both the right and the left.
And then Felix, from Greg Darley Emerson, concerning estate death taxes. With exclusions increasing, rates decreasing, and a plethora of strategies to avoid the tax altogether, how often does it actually come into play? Any sense of how much is actually collected in a year or from how many individuals? If the policy goal is to redistribute familial wealth, is there a better way aside from the harsh, quote unquote, estate tax?
Yeah, so that's a really good question. Thank you for that, Greg. You know, the empirical evidence from people who conduct these surveys or who conduct these empirical studies, it's really difficult to discern. But people who are particularly good at it, Thomas Piketty, of course, he's teamed up with with Sands, who's an economist at Berkeley. So Piketty, Sands, and others have really estimated that, you know, the global elite are dodging taxes. So there are so many ways to dodge taxes. And these recent leaks that we have in the news just illustrates that. So again, really people who are paying taxes are the middle class, the upper middle class, and even your multimillionaires who might not be able to afford the coterie of lawyers and to put their assets away in these jurisdictions. So I think part of your question asks, how effective is it really? So to answer it narrowly, you're right that with increasing exclusions, decreasing top rates, the estate tax is not capturing a whole bunch of people. I think for this reason, a lot of economists and more progressive lawmakers are proposing a wealth tax where you can't arbitrate across jurisdictions. So like a 2% wealth tax, no matter where your money is, you can't squirrel it away. That would require you know, global coordination on that. I think that tends to be quite difficult practically. I think that constitutional law scholars have said that a wealth tax might be constitutionally suspect. So part of your question then asks, you know, if I were king for a day, or maybe, you know, if I were just, let's just say if Justice Roberts for a day, the swing vote, what would I do, right? So if the policy goal is, as you say, to redistribute familial wealth, is there a better way? Probably the best way might be some sort of a global wealth tax. In implementation, I think that's hard. So a lot of what you have in law and especially legal scholarship is then looking at second best alternatives. And what I'm working with is in a framework of second best within that rubric of trust and estates. What is the second best? Hey, maybe you make it more difficult for ultra wealthy families to pass away wealth from one generation to the next. And maybe then in lower income households, maybe you narrow the scope of intestacy. I think that might be as best as we can practically hope for in the realm of trust and estates. But you're right that to truly remediate, you have to have a really broad system that requires global coordination, you know, some ability to raid these tax dodging jurisdictions like the Cook Islands, the British Virgin Islands, the Isle of Man, and increasingly, you know, US states like South Dakota, Delaware, and Nevada. Thanks for the question.
Okay, from Austin Wishart, does addressing hyper-rich estates and individuals avoiding taxation necessarily require addressing racial issues, or can solutions be reached solely through class dynamics? Thank you for your presentation and work.
Yeah, thanks very much for asking that, because the two perspectives I looked at, they seem to talk, they seem to be two ships passing the night. So the first perspective was really racial inequality, and a very narrow type of racial inequality, that is between a subset of Asian Americans. So the Korean American ethnicity and African Americans is this racialized group. The next thing was really looking at more of a class-based perspective, looking at wealth inequality. So, I think that when it comes to inequality, there's always going to be a racial dimension. And so the challenge then is defining exactly what we mean by inequality. There's some types of inequalities that you tolerate, so maybe income inequality. Other types of inequalities that you don't tolerate, so wealth inequality. There's inequality within a country, between the rich and the poor in the United States. There's inequality between countries, between the US and China or Vietnam, and that's what gives way to offshoring. Now, increasingly, there's inequality globally, so that you're beginning to see a global class of wealthy elites, no matter what country you're in, pulling away from everybody else. So that today, the hyper rich in the US looks not very much different, other than culturally, from the hyper rich in, say, China. So inequality has many different dimensions. When it comes to the trust and estates reforms, I do talk about the racial dimensions, but the racial dimensions, it does come up in the higher, in the ultra wealthy households, but it tends to really come up in lower income households. So I'll give you an example. So, when the drafters of the UPC or every state, when they go to write these intestacy rules, they have these notions of traditional families, quote unquote traditional families. So the single marriage family where children are not born out of wedlock, and that's not a term that I really like. Well, what's been found by scholars of intestacy is that, intestacy really has this racially disparate effect, is that oftentimes in many communities, intestacy has this disparate effect because oftentimes, I don't want to generalize, but in some communities, you might not have in these communities as many of these quote unquote traditional families. So we'll put our normative notions on that aside. Let me give you a really clear example. In the city of Cincinnati, that there's a lot of gentrification that's happening. Cincinnati is not different than any other major city. So you're seeing traditionally African-American communities in Avondale, in parts of the West Side, where you're beginning to see these land grabs by developers. How can that be? Well, you have these houses that were owned by multiple generations. So grandma passes away, grandma has a house, grandma forgets to write a will. What happens then if you've got the next generation that maybe cohabitated but did not marry one another? Well, what ends up happening if, intestacy laws is that you get a fractionated interest. So grandma's children, when they pass away, because oftentimes you can have racially disparate morbidity rates, you've got microaggressions, you've got epigenetic factors that get passed on, where you have lower life expectancies for Black and Brown communities. So for the next generation, they might pass away prematurely. Well, that next generation's interest in grandma's house gets fractionated. So then it goes on down where you have their descendants, each with a fractional interest in the home. They can't agree on how to manage the home. There's no upkeep in the house. Eventually there's back taxes where the city repossesses the house and then it gets sold to a developer. That is, for scholars of intestacy, the way in which a lot of houses in Black and Brown communities are getting passed on. They're being sold at these auctions by the city, and developers are grabbing them up. So that perhaps is an indirect way of answering your question, which is, I do think that the class-based approach is best to redressing wealth inequality, but we should not also discount the fact that some of these default rules, in particular intestacy, have a racially disparate effect.
Okay, Felix, I think you kind of addressed this in your last question, and that is from Joyce Lavender. I think in the history of America, one cannot talk about inequality in wealth without talking about ethnicity or race. Can we separate quote unquote poverty from race and wealth transfer?
Yeah, I can. I think we can, and I think we should. I absolutely think that, it should be, I think that it should be separated. But, I think in the race and law tradition, there's this thread that really pushes back against the notion of, facially neutral laws, and that they think that the race and law tradition is that racial hierarchies are embedded in every aspect of law. So to borrow from that tradition, I think that you can kind of see aspects of that in intestacy. I don't want to say that that explains everything, but we should also be mindful of that tradition as well.
Thank you so much for such an enlightening lecture, Professor Chang, and thank you so much, everyone, for being present here. We really appreciate your questions. Professor Chang, would you like to take any more questions, or I think we're...
Thank you. No, thanks to everybody for coming, for such a great showing, for supporting my work. Have a good week. Hope to see you all soon.
Thank you, everyone. Thank you, Felix. Great talk. Great to see you all. Bye-bye.
Thanks. Bye, everyone.
Thank you all.